But one farmer says, seems to me there was a tea party in Boston that was illegal too.
I have directed Secretary Connally to suspend temporarily the convertibility of the dollar into gold.
We shall seek to establish and maintain a dollar which will not change its purchasing and debt-paying power during the succeeding generation.
As anguished shrieks rose up from the floor of the New York Stock Exchange.
Government credit and government currency are really one and the same thing. A reserve of gold and a small reserve of silver.
Why do central banks hold it?
Well, it's a form of reserves.
Why don't they hold diamonds?
Well, it's tradition, long-term tradition.
Well, some people still think it's money.
Welcome back to the Junius Maltby channel, the most boring channel on YouTube. Today we are going to exceed the level of boredom which we've touched on in the past by once again reviewing Hepburn versus Griswold and the follow-up case Knox versus Lee, which overturned Hepburn versus Griswold, a Supreme Court case that is pivotal in understanding how we got to where we are today. This is likely one of the most destructive Supreme Court rulings in the United States history, a true violation of personal liberty, property rights, and something that ignited the fire that continues to burn down the United States economy. I want to touch on it, reading the opinions of the justices, and explain to you how I came to feel the way I do about this case and how it has truly shaped my view and motivation in running this channel and in spreading the word to the masses. It all started when I read The Federal War on Gold by Jacob Hornberger. I did read this back in about 2007, so quite some time ago. And this article is one of the key pieces that ignited the fire within me to fight what I consider the most injustice we've seen towards citizens using sound money and purchasing and selling, buying, bartering, trading, exchanging units of account for goods and services, you name it. I mean, this is one of the key stepping stones towards statism that this nation implemented. The dissenting opinions of the justices is really the key to understanding what went wrong here. Their predictions, incredible. So what we're going to do is we're going to read parts, some excerpts from the Federal War on Gold. I've done this entire reading of this article here on the channel. You can look it up. You can go and read the article yourself. Mr. Hornberger has done parts 1, 2, and 3 in writing. I have read this primary article here on the channel years ago. And now today we are going to venture into a little bit more depth of this case. I know it's going to be hard for some people to sit and listen to the entirety of it. That's okay if you want to break it up into time frames, listen to half now, half later, or whatever your decision might be. There is key information here, though. These are words that should not be forgotten. The rulings here, the dissent here should not be forgotten, and how this impacted the everyday transactions of the U.S. citizen and their ability to hold wealth, maintain wealth, and even loan money and receive payment from others. It's astounding. So just join me now. I'm not the smartest guy, not the sharpest tool in the shed, but there's some intelligent individuals that have made opinions based on this ruling. And that's what I'm going to do today, is just read these words and share with you some important information. So join me now as we journey into Hepburn versus Griswold. Lincoln's war loans. Then along came Lincoln. In 1862, Congress granted Lincoln's request to issue $150 million in Treasury notes to finance the war effort during the war between the states. In simple terms, the federal government was borrowing money, and the money it was borrowing was the gold and silver coins that had been established as the legal money under the Constitution. The situation would be comparable to a person who walked into a bank in 1862 and asked to borrow 10,000 US dollars. If the loan were granted, the customer would sign a promissory note promising to pay the bank $10,000, and the bank in turn would deliver $10,000 in gold coin to the customer. When the note came due, the customer would be required to pay the bank back $10,000 in gold coin, and he would receive back his promissory note with the notation paid or canceled on it. To belabor the obvious, the money was the gold coins. The note was a promise to repay the money, not money itself. The same principle held true with respect to the Treasury notes authorized to be issued by the Lincoln administration. Everyone understood that the notes didn't constitute money, but rather were a promise to pay back money, i.e. gold coins, it received in exchange for the notes. When the notes came due, the Treasury would have to repay the lender in money, that is, in gold coins. Given that the power to borrow money was among the powers that the Constitution delegated to Congress, there was obviously nothing unconstitutional about what Congress had done, except for one major factor that ultimately formed the basis for one of the most revolutionary transformations in American life. At the same time it authorized the issuance of the Treasury notes, Congress provided that the notes would constitute, quote, legal tender. What did legal tender mean? It meant paper money, and it meant that for the first time since the founding of the nation, Americans would be required to accept the federal government's paper money as a medium of exchange. Why was that important to Abraham Lincoln? Like so many other government officials in history, Lincoln was resorting to the printing press, inflation, to finance his war expenditures. In 1862, Treasury notes were trading at a deep discount relative to their face value. For example, a note promising to pay $1,000 might fetch in the marketplace only $500 because of the doubts that people had regarding the federal government's ability to repay the loans in gold when they ultimately came due. I'm going to pause here and interject some historical fact. Also, back then, you saw the fractional notes come out, notes that reflected 25 cents or 50 cents, because specie, silver coin, was being hoarded out of existence due to these very laws that we saw being passed and what was taking place during the war years of the Civil War. People were hoarding coin out of the marketplace, a pseudo-Gresham's Law type of event. And as a matter of fact, there was a large building in New York City, the floor of which collapsed under the weight of an individual who was hoarding away silver, copper, and gold because of these laws and the fear that these promissory notes, the bills issued by the government, could not be repaid in the true value, the true money, the sound money of which they represented. So it's very important here to understand that this immediately impacted the faith people had in the government and in the currency that represented the money. So a huge psychological component here and major economic implications in the United States at that time. In the absence of the legal tender law, even though the government could continue borrowing money, people could still protect themselves from the ravages of inflation by stipulating their contracts in gold coin. The effect of the legal tender law was to remove that protection by requiring creditors to accept depreciated paper money in lieu of gold and silver coin stipulated in the contract. That was exactly what happened to Henry Griswold and many other people. Prior to the enactment of the legal tender law, Griswold had lent $11,250 to Susan Hepburn. Obviously, both parties understood that when the note came due, Hepburn would be required to repay the debt in the medium in which she had received the loan, gold coin. When the note came due, however, Hepburn delivered to Griswold paper money, that is, U.S. Treasury notes that were the subject of the legal tender laws. Griswold objected because the notes, while nominally in the sum of $11,250, were worth significantly less in the marketplace. In other words, what Hepburn effectively did was go into the marketplace and use, say, $5,000 in gold coin to purchase $11,250 in Treasury notes, and then handed the notes to Griswold in payment of the debt. he refused to accept the payment and instead demanded gold coin with a face value of $11,250 plus interest owed. The Supreme Court's ruling. Hepburn versus Griswold reached the U.S. Supreme Court in 1869, 5 years after the war had ended. The court ruled in favor of Griswold, holding in a 4-3 decision that legal tender laws violated the U.S. Constitution. Now, this is where it should have ended. The Supreme Court made a ruling. They decided that the legal tender laws violated the U.S. Constitution, which I believe is still true. I believe that decision was the correct one. And that means to this day we have been living in violation of the U.S. Constitution after this ruling was overturned. And we're going to look at that in a moment. Because again, he was victorious initially. But things changed when the womanizing drunk Grant reappointed Supreme Court justices. So let's continue on here in this tragic tale of our history. The majority opinion distinguished between money and notes to pay money. There is a well-known law of currency that notes or promises to pay, unless made conveniently and promptly convertible into coin at the will of the holder, can never, except under unusual and abnormal conditions, be at par in circulation with coin. It is an equally well-known law that depreciation of notes must increase with the increase of the quantity put in circulation, and the diminution of confidence in the ability or disposition to redeem. Their appreciation follows the reversal of these conditions. No act making them a legal tender can change materially the operation of these laws. Let's read that part again. No act making them a legal tender can change materially the operation of these laws. The court also explained that the power to coin money, which the Constitution delegates to Congress, did not constitute a power to convert promissory notes into money. It is not doubted that the power to establish a standard of value by which all other values may be measured, or in other words, to determine what shall be lawful money and a legal tender, is in its nature and of necessity a governmental power. It is in all countries exercised by the government. In the United States, so far as it relates to the precious metals, it is vested in Congress by the grant of the power to coin money. But can a power to impart these qualities to notes or promises to pay money when offered in discharge of pre-existing debts be derived from the coinage power or from any other power expressly given? It is certainly not the same power as the power to coin money. With the holding in Griswold, the federal government was left with the power to borrow to finance its operations, but without the authority to force people to accept its notes at face value for the payment of debts. Thus, the American people could still protect themselves from a profligate government by expressly providing that notes and contracts could be repaid only in money, gold coin, not in federal promises to repay money. Everyone has their personal choice of who they'd go back in time in a time machine and assassinate. They have their little time machine hit list, and one of mine would be President Ulysses S. Grant, the alcoholic womanizer. And let's take a look here at Overturning Griswold and continue on. 1 year later, however, the legal situation changed dramatically. President Ulysses S. Grant, who had commanded Union forces during the war, appointed 2 new justices to the Supreme Court who promptly joined the minority in Griswold. In Knox versus Lee, decided in 1879, the Supreme Court voted to overturn the decision in Griswold and to uphold the constitutionality of Lincoln's legal tender law. So the Knox versus Lee is really the key case, overturning Hepburn versus Griswold, that led us on this path of destruction. The Griswold case was a victory for the people and a preservation of the values and the right way in which the founders had organized and drafted the Constitution and Congress's ability to coin money, and declaring that only gold and silver coin could be money. And when they changed that here, as we'll see, we took a much different direction in the course of our nation's history and in the view and the definitions of what is money versus currency. The new majority reasoned that the power to enact a legal tender law was an implied power that fell under the president's war powers and the power over monetary affairs that the Constitution had granted to Congress. But as the dissent pointed out, the implied powers doctrine cannot be used to create new powers. The war power, for example, entails the power to pay for war expenditures, but the means by which to pay for such expenditures were limited to those enumerated in the Constitution, i.e. through taxes and borrowing. As the dissent also emphasized, the congressional power over monetary affairs was specifically limited to the coinage of money and did not extend to the enactment of laws requiring people to accept federal promissory notes in lieu of such money. In a separate dissenting opinion, Justice Stephen J. Field pointed out the obvious. The power to coin money is, in my judgment, inconsistent with and repugnant to the existence of a power to make anything but coin a legal tender. To coin money is to mold metallic substances, having intrinsic value, into certain forms convenient for commerce, and to oppress them with the stamp of the government indicating their value. Coins are pieces of metal, of definite weight and value, thus stamped by national authority. Such is the natural import of the terms to coin money and coin. The power to coin money is therefore a power to fabricate coins out of metal as money, and thus make them a legal tender for their declared values as indicated by their stamp. If this be the true import and meaning of the language used, it is difficult to see how Congress can make the paper of the government a legal tender. Field placed the constitutional issue in a historical context. The statesmen who framed the Constitution understood this principle as well as it is understood in our day. They had seen, in the experience of the Revolutionary period, the demoralizing tendency, the cruel injustice, and the intolerable oppression of a paper currency not convertible on demand into money, and forced into circulation by legal tender provisions and penal enactments. Field also pointed out that the Constitution had not delegated to Congress the power to impair private contracts. With Knox v. Lee, the seeds were sown for a monetary revolution in American life, a revolution that would bring the inflationary plunder and moral debauchery that have characterized nations throughout history. The revolution began with Lincoln, but it would culminate in one of most massive assaults on private property in U.S. history. President Franklin Roosevelt's nullification of gold clauses in contracts and his confiscation of gold from the American people. And that's described further on in the article, The Federal War on Gold. Let's get some background on Knox versus Lee. After her sheep were confiscated and sold by the Confederate Army, Mrs. Lee filed suit against the purchaser, Mr. Knox, for damages. In the trial that followed, the court instructed the jury as follows. In assessing damages, the jury will recollect that whatever amount they may give by their verdict can be discharged by the payment of such amount in legal tender notes of the United States. Mr. Knox appealed, arguing that instruction essentially directed the jury to account for the discounted value of paper currency when awarding damages. The court upholds the Legal Tender Act in Knox v. Lee. By a vote of 5-4, the court upheld the Legal Tender Act. The acts of Congress known as the legal tender are constitutional when applied to contracts made before their passage. They are also valid as applicable to contracts made since, Justice William Strong wrote on behalf of the majority. In his opinion, Justice Strong highlighted that Congress wields significant power under the necessary and proper clause of the Constitution. He wrote, and here it is to be observed, it is not indispensable to the existence of any power claimed for the federal government that it can be found specified in the words of the Constitution or clearly and directly traceable to someone of the specified powers, existence may be deduced fairly from more than one of the substantive powers expressly defined, or from them all combined. It is allowable to group together any number of them, and infer from them all that the power claimed has been conferred. Such a treatment of the Constitution is recognized by its own provisions. The majority also rejected the argument that the Legal Tender Act was forbidden by the letter or spirit of the Constitution because Congress is only expressly given the power to coin money, regulate the value thereof, and of foreign coin. As explained by Justice Strong, the fact that Congress was given certain powers over the currency does not imply that all other powers relating to the same subject are impliedly forbidden. Quote, such is not the manner in which the Constitution has always been construed. On the contrary, it has been ruled that power over a particular subject may be exercised as auxiliary to an express power, though there is another express power relating to the same subject, less comprehensive, unquote, he added. Legal tender cases, law cases, legal tender cases, 1870, 1871. This is some additional information. 2 cases decided by the Supreme Court regarding the power of Congress to authorize government notes not backed by specie, as money, that's gold and silver, that creditors had to accept in payments of debts. We're going to look at some other opinions here from the justices regarding these 2 cases, specifically Hepburn versus Griswold. That's the case that I really want to dive into. To finance the Civil War, the federal government in 1862 passed the Legal Tender Act, authorizing the creation of money not redeemable in gold or silver. About $430 million worth of greenbacks were put into circulation, and this money, by law, had to be accepted for all taxes, debts, and other obligations, even those contracted prior to the passage of the Act. In Hepburn v. Griswold, February 7, 1870, the court ruled by a 4-3 majority that Congress lacked the power to make the notes legal tender. Chief Justice Salmon P. Chase, who, as Secretary of the Treasury during the Civil War, had been involved in enacting the Legal Tender Act, wrote the majority opinion declaring that the congressional authorization of greenbacks as legal tender violated the Fifth Amendment guarantees against deprivation of property without due process of law. On the day the decision was announced, a disapproving President Grant sent the nominations of 2 new justices to the Senate for confirmation. Justices Bradley and Strong were confirmed. And at the next session, the court agreed to reconsider the greenback issue. Look how quickly the president nominated 2 new justices and how quickly they reviewed the case of Hepburn versus Griswold to overturn it. This is already showing the motivation of the federal government to steal, to quietly use theft from the wealth of the people to fund their endeavors. Nothing is more clear than the case of Hepburn versus Griswold and its overturning in Knox versus Lee by the actions of President Grant and the justices Bradley and Strong, who he put on the court to do his bidding. In Knox versus Lee and Parker versus Davis was also decided during Knox versus Lee, the court reversed its Hepburn versus Griswold decision by a 5-4 majority, asserting that the Legal Tender Act of 1862 represented a justifiable use of federal power at a time of national emergency. Here is the syllabus from the U.S. Supreme Court, Hepburn versus Griswold, 75 U.S. And let's go through one of these at a time. There's many of them. 1. Construed by the plain import of their terms and the manifest intent of the legislature, the statutes of 1862 and 63, which make United States notes a legal tender in payments of debts, public and private, apply to debts contracted before as well as to debts contracted after enactment. 2. The cases of Lane County versus Oregon, Bronson versus Rhodes, and Butler versus Horowitz, and then it's got your codes there, in which it was held that upon a sound construction of those statutes, neither taxes imposed by state legislation nor dues upon contracts for the payment or delivery of coin or bullion are included by legislative intent under the description of debts public and private, are approved and reaffirmed. When a case arises for judicial determination and the decision depends on the alleged inconsistency of a legislative provision with the Constitution, It is the plain duty of the Supreme Court to compare the act with the fundamental law, and if the former cannot, upon a fair construction, be reconciled with the latter, to give effect to the Constitution rather than the statute. There is in the Constitution no express grant of legislative power to make any description of credit, currency, a legal tender in payment of debts. The words, all laws necessary and proper for carrying into execution powers expressly granted of vested, have, in the Constitution, a sense equivalent to that of the words laws, not absolutely necessary, indeed, but appropriate, plainly adapted to constitutional and legitimate ends, which are not prohibited, but consistent with the letter and spirit of the Constitution, laws really calculated to affect objects entrusted to the government. 6. Among means appropriate, plainly adapted, not inconsistent with the spirit of the Constitution, nor prohibited by its terms, the legislature has unrestricted choice, but no power can be derived by implication from any express power to enact laws as means for carrying it into execution unless such laws come within this description. 7. The making of notes or bills of credit a legal tender in payment of pre-existing debts is not a means appropriate, plainly adapted, or really calculated to carry into effect any express power vested in Congress, is inconsistent with the spirit of the Constitution, and is prohibited by the Constitution. 8. The clause in the Acts of 1862 and 1863, which makes United States notes a legal tender in payment of all debts, public and private, is so far as it applies to debts contracted before the passage of those acts unwarranted by the Constitution. Prior to the 25th of February 1862, all contracts for the payment of money, not expressly stipulating otherwise, were, in legal effect and universal understanding, contracts for the payment of coin, and under the Constitution the parties to such contracts are respectively entitled to demand and bound to pay the sums due according to their terms in coin, notwithstanding the clause in that act and the subsequent acts of like tenor, which make United States notes a legal tender in payment of such debts. On the 20th of June, 1860, a certain Mrs. Hepburn made a promissory note by which she promised to pay to Henry Griswold on the 20th of February, 1862, $11,250, dollars. At the time when the note was made, as also at the time when it fell due, there was confessedly no lawful money of the United States or money which could lawfully be tendered in payment of private debts, but gold and silver coin. 5 days after the day when the note by its terms fell due, that is to say, on the 25th of February, 1862, in an exigent crisis of the nation in which the government was engaged in putting down an armed rebellion of vast magnitude, Civil War, Congress passed an act authorizing the issue of $150 million of its own notes, and enacted in regard to them by one clause in the first section of the act as follows, quote, and such notes herein authorized shall be receivable in payments of all taxes, internal duties, excises, debts, and demands of every kind due to the United States, except duties on imports, and of all claims and demands against the United States of every kind whatsoever, except for interest upon bonds and notes, which shall be paid in coin, and shall also be lawful money and a legal tender in payment of all debts, public and private, within the United States, except duties on imports and interest as aforesaid. The note given by Mrs. Hepburn not being paid at maturity, interest accrued on it, and in March 1864, a suit having been brought on the note in the Louisville Chancery Court, she tendered in United States notes issued under the act mentioned $12,720. The amount of principal of the note, with the interest accrued to the date of tender, and some costs in satisfaction on the plaintiff's claim. The tender was refused. The notes were then tendered and paid into court, and the Chancellor resolving all doubts in favor of the Congress, declared the tender good, and adjudged the debt, interest, and costs to be satisfied accordingly. The case was then taken by Griswold to the Court of Errors of Kentucky, which reversed the Chancellor's judgment and remanded the case with instructions to enter a contrary judgment. From the judgment of the Court of Errors of Kentucky, the case was brought by Mrs. Hepburn here. With regards to Hepburn versus Griswold, the Chief Justice delivered this. And I'm going to skip to some key points here that we will read. I'm not going to read the entirety of his discourse because it's quite lengthy. So let's go to right here. The delicacy and importance of this question has not been overstated in the argument. This court always approaches the consideration of questions of this nature reluctantly, and its constant rule of decision has been, and is, that acts of Congress must be regarded as constitutional unless clearly shown to be otherwise. But the Constitution is the fundamental law of the United States. By it, the people have created a government, defined its powers, prescribed their limits, distributed them among the different departments, and directed, in general, the manner of their exercise. No department of the government has any other powers than those thus delegated to it by the people. All the legislative power granted by the Constitution belongs to Congress, but it has no legislative power which is not thus granted. And the same observation is equally true in its application to the executive and judicial powers granted respectively to the President and the courts. All these powers differ in kind, but not in source or in limitation. They all arise from the Constitution and are limited by its terms. It is the function of the judiciary to interpret and apply the law to cases between parties as they arise for judgment. It can only declare what the law is and enforce by proper process the law thus declared. But in ascertaining the respective rights of parties, it frequently becomes necessary to consult the Constitution, for there can be no law inconsistent with the fundamental law. No enactment not in pursuance of the authority conferred by it can create obligations or confer rights. For such is the express declaration of the Constitution itself in these words: "The Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges of every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding." Not every act of Congress, then, is to be regarded as the supreme law of the land, nor is it by every act of Congress that the judges are bound. This character and this force belong only to such acts as are made in pursuance of the Constitution. When therefore a case arises for judicial determination, and the decision depends on the alleged inconsistency of a legislative provision with the fundamental law, he's referring to the Constitution, it is the plain duty of the court to compare the act with Constitution, and if the former cannot, upon a fair construction, be reconciled with the latter, to give effect to the Constitution rather than the statute. This seems so plain that it is impossible to make it plainer by argument. If it be otherwise, the Constitution is not the supreme law. It is neither necessary or useful, in any case, to inquire whether or not any act of Congress was passed in pursuance of it, and the oath which every member of this court is required to take, that he will administer justice without respect to persons, and do equal right to the poor and the rich, and faithfully perform the duties incumbent upon him to the best of his ability, and understanding agreeably to the Constitution, the laws of the United States, becomes an idle and unmeaning form. The case before us is one of private right. The plaintiff in the court below sought to recover of the defendants a certain sum expressed on the face of a promissory note. The defendants insisted on the right under the Act of February 25, 1862, to acquit themselves of their obligation by tendering in payment a sum nominally equal in United States notes. But the note had been executed before the passage of the Act, and the plaintiff insisted on his right under the Constitution to be paid the amount due in gold and silver. And it has not been, and cannot be, denied that the plaintiff was entitled to judgment according to his claim, unless bound by a constitutional law to accept the notes as coin. Thus, two questions were directly presented. Were the defendants relieved by the Act from the obligation assumed in the contract? Could the plaintiff be compelled by a judgment of the court to receive in payment a currency of different nature and value from that which was in the contemplation of the parties when the contract was made? The Court of Appeals resolved both questions in the negative, and the defendants, in the original suit, seek the reversal of that judgment by writ of error. It becomes our duty, therefore, to determine whether the Act of February 25, 1862, so far as it makes United States notes a legal tender in payment of debts contracted prior to its passage, is constitutional and valid or otherwise. Under a deep sense of our obligation to perform this duty, to the best of our ability and understanding, we shall proceed to dispose of the case presented by the record. We have already said, and it is generally, if not universally conceded, that the government of the United States is one of limited powers, and that no department possesses any authority not granted by the Constitution. I'm skipping ahead again as he goes on to really paint the picture of the strength and the foundation of the Constitution being the law of the land here. And he goes on to say, it must be taken then as finally settled, so far as judicial decisions can settle anything, that the words all laws necessary and proper for carrying into execution, powers expressly granted or vested have, in the Constitution, a sense equivalent to that of the words laws not absolutely necessary indeed, but appropriate, plainly adapted to constitutional and legitimate ends, laws not prohibited, but consistent with the letter and spirit of the Constitution, laws really calculated to affect objects entrusted to the government. The question before us then resolves itself into this: is the clause which makes the United States notes a legal tender for debts contracted prior to its enactment a law of the description stated in the rule? It is not doubted that the power to establish a standard of value by which all other values may be measured, or in other words, to determine what shall be lawful money and a legal tender, is in its nature and of necessity a governmental power. It is in all countries exercised by the government. In the United States, so far as it relates to the precious metals, it is vested in Congress by the grant of the power to coin money. But can a power to impart these qualities to notes or promises to pay money when offered in discharge of pre-existing debts be derived from the coinage power or from any other power expressly given? It is certainly not the same power as the power to coin money, nor is it in any reasonable or satisfactory sense an appropriate or plainly adapted means to the exercise of that power. Nor is there more reason for saying that it is implied in or incidental to the power to regulate the value of coin money of the United States or of foreign coins. This power of regulation is a power to determine the weight, purity, form, impression, and denomination of the several coins, and their relation to each other, and the relations of foreign coins to the monetary unit of the United States. Nor is the power to make notes a legal tender the same as the power to issue notes to be used as currency. The old Congress, under the Articles of Confederation, was clothed by express grant with the power to emit bills of credit, which are in fact notes for circulation as currency. And yet that Congress was not clothed with the power to make these bills a legal tender in payment, and this court has recently held that the Congress, under the Constitution, possesses as incidental to other powers the same power as the old Congress to emit bills or notes, but it was expressly declared at the same time that this decision concluded nothing on the question of legal tender. Indeed, we are not aware that it has ever been claimed that the power to issue bills or notes has any identity with the power to make them a legal tender. On the contrary, the whole history of the country refutes that notion. The states have always been held to possess the power to authorize and regulate the issue of bills for circulation by banks or individuals, subject, as has been lately determined, to the control of Congress for the purpose of establishing and securing a national currency, and yet the states are expressly prohibited by the Constitution from making anything but gold and silver coin a legal tender. This seems decisive on the point that the power to issue notes and the power to make them a legal tender are not the same power, and that they have no necessary connection with each other. But it has been maintained in argument that the power to make United States notes a legal tender in payment of all debts is a means appropriate and plainly adapted to the execution of the power to carry on war, of the power to regulate commerce, and of the power to borrow money. If it is, and is not prohibited, nor inconsistent with the letter or spirit of the Constitution, then the act which makes them such legal tender must be held to be constitutional. Let us then first inquire whether it is an appropriate and plainly adapted means for carrying on war. The affirmative argument may be thus stated. Congress has power to declare and provide for carrying on war. Congress has also power to emit bills of credit or circulating notes receivable for government dues and payable, so far at least as parties are willing to receive them. In discharge of government obligations, it will facilitate the use of such notes and disbursements to make them a legal tender in payment of existing debts. Therefore, Congress may make such notes a legal tender. It is difficult to say to what express power the authority to make notes a legal tender in payment of pre-existing debts may not be upheld as incidental upon the principles of this argument. Is there any power which does not involve the use of money? And is there any doubt that Congress may issue and use bills of credit as money in the execution of any power? The power to establish post offices and post roads, for example, involves the collection and disbursement of a great revenue. Is not the power to make notes a legal tender as clearly incidental to this power as to the war power? The answer to this question does not appear to us doubtful. The argument therefore seems to prove too much. It carries the doctrine of implied powers very far beyond any extent hitherto given to it. It asserts that whether in any degree promotes an end within the scope of a general power, whether in the correct sense of the word, appropriate or not, may be done in the exercise of an implied power. Can this proposition be maintained? Skipping quite ahead here because these guys seem to talk at length in these dissertations that they have, but there is another view which seems to us decisive. To whatever express power the supposed implied power in question may be referred. In the rule stated by Chief Justice Marshall, the words appropriate, plainly adapted, really calculated, are qualified by the limitation that the means must be not prohibited, but consistent with the letter and spirit of the Constitution. Nothing so prohibited or inconsistent can be regarded as appropriate or plainly adapted or really calculated means to any end. Let us inquire, then, first, whether making bills of credit a legal tender, to the extent indicated, is consistent with the spirit of the Constitution. Among the great cardinal principles of that instrument, no one is more conspicuous or more venerable than the establishment of justice. And what was intended by the establishment of justice in the minds of the people who ordained it is, happily, not a matter of disputation. It is not left to inference or conjecture, especially in its relations to contracts. When the Constitution was undergoing discussion in the Convention, the Congress of the Confederation was engaged in the consideration of the ordinance for the government of the territory northwest of the Ohio, the only territory subject at that time to its regulation and control. By this ordinance, certain fundamental articles of compact were established between the original states and the people and states of the territory for the purpose, to use its own language, of extending the fundamental principles of civil and religious liberty whereon these republics, the states united under the Confederation, their laws and constitutions are erected. Among these fundamental principles was this: in the just preservation of rights and property, it is understood and declared that no law ought ever to be made or have force in the said territory that shall in any manner whatever interfere with or affect private contracts or engagements bona fide and without fraud previously formed. The same principle found more condensed expression in that most valuable provision of the Constitution of the United States ever recognized as an efficient safeguard against injustice, that no state shall pass any law impairing the obligation of contracts. It is true that this prohibition is not applied in terms to the government of the United States. Congress has express power to enact bankrupt laws, and we do not say that a law made in the execution of any other express power, which incidentally only impairs the obligation of a contract, can be held to be unconstitutional for that reason. But we think it clear that those who framed and those who adopted the Constitution intended that the spirit of this prohibition should pervade the entire body of legislation, and that the justice which the Constitution was ordained to establish was not thought by them to be compatible with legislation of an opposite tendency. In other words, we cannot doubt that a law not made in pursuance of an express power, which necessarily and in its direct operation impairs the obligation of contracts, is inconsistent with the spirit of the Constitution. Starting at the second paragraph here. But there is another provision in the same amendment, which, in our judgment, cannot have its full and intended effect unless construed as a direct prohibition of the legislation which we have been considering. It is that which declares that no person shall be deprived of life, liberty, or property without due process of law. It is not doubted that all the provisions of this amendment operate directly in limitation and restraint of the legislative powers conferred by the Constitution. The only question is whether an act which compels all those who hold contracts for the payment of gold and silver money to accept in payment a currency of inferior value deprives such persons of property without due process of law. It is quite clear that whatever may be the operation of such an act, due process of law makes no part of it. Does it deprive any person of property? A very large proportion of the property of civilized men exists in the form of contracts. These contracts almost invariably stipulate for the payment of money, and we have already seen that contracts in the United States prior to the act under consideration for the payment of money were contracts to pay the sums specified in gold and silver coin, and it is beyond doubt that the holders of these contracts were and are as fully entitled to the protection of this constitutional provision as the holders of any other description of property. But it may be said that the holders of no description of property are protected by it from legislation, which incidentally only impairs its value. And it may be urgent in illustration that the holders of stock in a turnpike, a bridge, or a manufacturing corporation, or an insurance company, or a bank cannot invoke its protection against legislation which, by authorizing similar works or corporations, reduces its price in the market. But all this does not appear to meet the real difficulty. In the cases mentioned, the injury is purely contingent and incidental. In the case we are considering, it is direct and inevitable. If, in the cases mentioned, the holders of the stock were required by law to convey it on demand to anyone who should think fit to offer half its value for it, the analogy would be more obvious. No one probably could be found to contend that an act enforcing the acceptance of 50 or 75 acres of land in satisfaction of a contract to convey 100 would come within the prohibition against arbitrary privation of property. We confess ourselves unable to perceive any solid distinction between such an act and an act compelling all citizens to accept in satisfaction of all contracts for money half or 3/4 or any other proportion less than the whole of the value actually due according to their terms. It is difficult to conceive what act would take private property without process of law if such an act would not. We are obliged to conclude that an act making mere promises to pay dollars, a legal tender in payment of debts previously contracted, is not a means appropriate, plainly adapted, really calculated to carry into effect any express power vested in Congress, that such an act is inconsistent with the spirit of the Constitution, and that it is prohibited by the Constitution. It is not surprising that amid the tumult of the late Civil War, and under the influence of apprehensions for the safety of the Republic almost universal, different views, never before entertained by American statesmen or jurists, were adopted by many. The time was not favorable to considerate reflection upon the constitutional limits of legislative or executive authority. If power was assumed from patriotic motives, the assumption found ready justification in patriotic hearts. Many who doubted yielded their doubts. Many who did not doubt were silent. Some who were strongly averse to making government notes a legal tender felt themselves constrained to acquiesce in the views of the advocates of the measure. Not a few, who then insisted upon its necessity or acquiesced in that view, have since the return of peace and under the influence of calmer time reconsidered their conclusions and now concur in those which we have just announced. These conclusions seem to us to be fully sanctioned by the letter and spirit of the Constitution. We are obliged, therefore, to hold that the defendant in error was not bound to receive from the plaintiffs the currency tendered to him in payment of their note made before the passage of the Act of February 25, 1862. It follows that the judgment of the Court of Appeals of Kentucky must be affirmed. It is proper to say that Mr. Justice Greer, who was a member of the court when this cause was decided in conference, and when this opinion was directed to be read, stated his judgment to be that the legal tender clause, properly construed, has no application to debts contracted prior to its enactment, but that upon the construction given to the act by the other judges, he concurred in the opinion that the clause, so far as it makes United States notes a legal tender for debts, is not warranted by the Constitution. Judgment affirmed. That is, until the ruling of Knox versus Lee, which overturned the Hepburn versus Griswold. So what we witnessed back then was a turning point, a true turning point. A violation of private property rights, government intrusion into the private contracts and dealings between individuals, the issuance of unbacked currency, essentially, with the greenback. They were not redeemable for the amount of gold or silver which were declared on them in face. In this situation, I would say we exist in a post-Constitution era ever since this time. I mean, truly, the Constitution was just a piece of paper to these individuals, and as soon as they could exploit it, begin to violate it, the ends justified the means. As long as they could steal wealth away or do whatever necessary to exercise war, see their endeavors funded through the theft of the wealth of the people, they would do so, and they would do it with verbal jujitsu, just creating words, appointing justices that would do their bidding. And ever since that time period, I guess you could say the United States didn't last very long. I mean, it's been devolving ever since that Civil War era. And there's been more laws and executive orders since then. I mean, FDR truly was able to compound and accelerate the destruction of the wealth of the people, the U.S. economy, the currency, the dollar. in the many actions he did with the New Deal. And all of that is also part of the Federal War on Gold article. But I just wanted to point out here that one of the big things here, the big takeaway, is there were justices that understood truly how simple the law of this land was and should have been. That you could not deprive mankind of property without due process. You could not just steal it away. That the government itself, Congress, the executive branch, the judicial branch, were all bound to operate within the confines of the Constitution. However they strayed from that, it was violated, and the consequences were not enforced. It's incredible that the ruling of Hepburn versus Griswold was so easily overturned by appointing justices, and that we never looked back, and that the nation itself forgot such an act and forgot such discourse and language. It's sad. I mean, you really should grieve what we lost hundreds of years ago. There's truly, I guess, no way going back. I mean, how do you rectify such an act, such a decision? I mean, what do we do? Tell Congress, the Supreme Court today that, hey, we need to go back and review this. Because if they overturned Hepburn versus Griswold once with Knox versus Lee, they could easily overturn Knox versus Lee and reinstate Hepburn versus Griswold and maybe do something. But the Legal Tender Act truly is government incursion into our everyday lives. I mean, we do need competing currencies. You should not be forced to use the U.S. dollar in your day-to-day transactions. You should be able to write a contract to be paid in gold instead of U.S. dollars. And we all know that you cannot do that. That is impossible today. And just, it's one of these stepping stones that we need to look at. It was definitely the road to serfdom, the road to tyranny, the road to statism was paved with rulings such as Knox versus Lee and cases like Hepburn versus Griswold being overturned. Very important piece of the history here in the United States. My apologies for such a lengthy reading. I know I skipped over quite a bit. There's a lot of different dissenting opinions and discourse and writings related to these cases. You can go off and read them on your own if you wish to do so. I definitely encourage reading the Federal War on Gold if you get a chance. But thanks for tuning in for probably one of the longest broadcasts ever. Looking at an hour here. I appreciate it. All of you have a good rest of your evening and rest of your weekend. Take care now, and thanks for tuning in to the Junius Maltby channel.